Just a word of caution, this podcast does contain material related to sexual assault which could be upsetting to some listeners. Please make sure you're emotionally resourced and seek help from a trauma specialist or medical professional if you need it.
Virginia Woolf suffered from what she called looking-glass shame, an aversion to seeing herself in mirrors. How do we understand our own sufferings? With what words and to what ends?
Tell it to me straight, don't leave out a word, don't leave out anything you think I should have heard.
Hi, and welcome to Slut or Nut, the podcast. I'm Kelly Shoker, and I'm the director of Slut or Nut, The Diary of a Rape Trial, which is a feature-length documentary film exploring what it is like to report rape and following activist Mandi Gray as she fights to change how victims of sexual assault are treated by the criminal justice system. You can also find the show notes related to this episode on our site and more episodes of Slut or Nut the podcast on Apple Podcasts, Spotify, Stitcher, and on our website at www.slutornut.ca. And if you'd like to share your own story of sexual assault, gender-based violence, or your expertise on the legal system or trauma related to sexual assault, and you'd like to be a guest on our podcast, please email us at slutornutthemovie@gmail.com. So for this episode, we chatted with Justice Marvin Zuker, who is the judge who presided over R versus Ururyar, which is the trial that is followed in the documentary film Slut or Nut, The Diary of a Rape Trial. To give you some context, the case involved Mr. Ururyar, who was accused of raping Mandi Gray. And in Canada, for these types of rapes, which you could call an acquaintance rape, innocence or guilt of the person accused of the rape is decided by a judge, not by a jury. So it's just decided by one person, and in this case, it was decided by Justice Zuker, who you're about to hear from. Justice Zuker is a very experienced judge. He has retired since the time of this recording, but he presided over hundreds of criminal and family court cases involving sexual assault for over 30 years. He's also written and co-authored several books, including Canadian Women in the Law, The Children's Law Handbook, Educational Law, and Inspiring the Future, a new teacher's guide to the law. Finally, he is currently teaching at the University of Toronto, and he teaches law. I witnessed Zuker in court myself. I attended the trial, and I found what he had written to be very powerful. So to begin with, I've asked him just to read a few excerpts of the verdict. The whole thing was over 100 pages long, so we can't get into the whole thing, but we're going to start with a few powerful excerpts, and then we'll get into discussion around the verdict. Here we go.
It is important to understand the unique dynamics, distinct emotional trauma, and realities of sexual assault, because many assaults are committed by someone who is formally trusted. Many victims, survivors do not label their experience as being sexual assault or rape. There are a number of reasons why individuals delay or the failure to report sexual assault, including that they do not see the incidents as serious enough to report, are not clear that a crime was committed, do not want family involved, fear of retaliation, fear of police treatment, lack of proof about the incident. Going to Women's College Hospital, then Mount Sinai Hospital, waiting 48 hours, 72 hours to go to the police. Is long ever too long? Does pain have a time limit? With or without all the text, Mr. Ururyar raped Miss Gray. We don't need the missing text to know this. Rape it surely was. The experience of rape invades not only the body, but the mind of its victims. Disassociation kicks in, often with great efficiency, and often there is a desperate wish by the victim to please the rapist, a desperate hope that the rape will end and maybe, just maybe, I will survive. Often rape victims become their own legal advocates, one opportunity perhaps for retribution. No other crime is looked upon with a degree of blameworthiness, suspicion, and doubt as a rape victim. Victim blaming is unfortunately common and is one of the most significant barriers to justice and offender accountability. What makes someone a perfect target in the context of alcohol-facilitated sexual assaults may make that person a poor witness in any ensuing proceedings due to his or her inability to remember part or all of what happened. Victim blaming can be expressed in several ways. Victim masochism, e.g., she enjoyed it, wanted it. Victim precipitation, e.g., she asked for it or brought it on herself, or victim fabrication. It doesn't matter if the victim was drinking, out at night alone, sexually exploited, on a date with the perpetrator, or how the victim was dressed. No one asks to be raped. The responsibility and blame lie with the perpetrator who takes advantage of a vulnerable victim or violates the victim's trust to commit the crime of sexual assault. Mr. Ururyar gave evidence, as we heard, his version, and I stress his version, without reality. It never happened. Such a scenario we heard from Mr. Ururyar from beginning to end begs credulity, a feeble attempt in hindsight that is unbelievable and incomprehensible.
In the trial, the Crown talked a lot about what she called the rape myth catalog, which included tactics the defense used to discredit the witness and victim blaming. Could you talk about why you felt it was so important to include this in your verdict?
I think that some of this relate to the myths of rape. I wanted to address these in my decision because of suggestions that were made, not only in this trial, but other trials. The stereotyping of victims. If you wait to report it, it didn't happen. That's part of the catalog, waiting. That somehow because if they wait, it never happened. But often things will happen that may take a second or a minute or an hour. And often people will not forget what happened. So, and many people wait not only hours, but days, months, and as we know, years. So that's what I say is too long, ever too long. Does pain have a time limit? And quite frankly, in my opinion, pain does not have a time limit. Everyone deals with pain in their own way. And also the comment about disassociation that I was trying to address. If questions are asked, what hand did he use? If someone's hit by a car and they're asked how many doors does the car have? Or what color was the car? Quite frankly, I think it's ridiculous. When you're involved in trauma, you're not going to remember. But again, the failure to remember has historically been equated with the fact that something didn't happen. If you don't remember each and everything that happened, if you don't remember the details, it never happened. I remember everything because it happened, and you don't remember anything. Therefore, you're not credible. You're not trustworthy. Different people who have been subject to sexual assaults react differently. What do you do if you're being sexually assaulted? What are you supposed to do? There's no answer. And really, the bottom line is no one asks to be raped. You go back to someone's home, you sit on their bed. That doesn't give a license to perpetrate a rape.
In Mandi's case, she was accused of having a political agenda, and that was used by the defense to try and discredit her testimony. They even said that she had been an advocate to other women in the justice system, and that was, grounds for questioning her testimony. Can you comment on that?
My reference, of course, to rape victims becoming their own legal advocates, because we know by reading that the newspapers or otherwise that rape victims do become advocates. So this is another I guess, rape catalog,
The agenda.
Yeah. Well, you say you were raped and now you're in the press a lot. I mean, the suggestion seemed to be, why would somebody go through all of this who wasn't raped? It makes no sense. If people want to find an agenda, they'll find an agenda. All I know is what I heard on the stand, and I'm the judge. The judge is sitting there listening to the evidence, listening to the cross-examination of the evidence. She's being cross-examined. And hypothetically, the counsel for the accused can discredit anything anybody says. So there's a protection there. You know, the right to cross-examine is protection.
So this is the only rape trial that I've actually personally attended. And what really struck me was how long Mandi was on the stand. It seemed like she was on the stand for about 90% longer than the accused was on the stand for. And I know sometimes the accused never take the stand. So it could be the victim's on the stand for 100% longer. Is this something victims should expect when they go to report rape? Should they expect to be on the stand for, 4 hours, 5 hours, 6 hours, 10 hours, 4 days in a row? Is this normal, or was this an atypical situation?
It probably was a bit unusual because they hadn't even known each other. They only knew each other, a few weeks? That was it. So there wasn't that much history, to cross-examine on. So perhaps in that context, it was long, but different lawyers have different strategies. And certainly when you're dealing with this kind of a crime, then they're not going to rush. I mean, at some point, a judge can intercede and say, well, you've asked that question before, you've asked it again, or, why are you asking it again? Certainly lawyers have a right to cross-examine. Nobody's questioning that. You want to ask questions about facts? Ask questions about facts. Facts aren't usually, if somebody sends an email or doesn't send an email, that's a fact. Somebody writes a letter, that's a fact. Somebody's on the cell phone, that's a fact. Somebody's on the social media, that's a fact. But don't ask questions that perpetuate myths. Like, why did you wait so long? What does that mean? Let's not perpetuate the myths.
Part of the verdict that I found particularly powerful was the section where you did quote feminist authors. And I know this was really criticized in the media, but I found it very moving. So let's get into that section and we'll hear it, and then we'll talk about your choices.
Rape in the case of Maya Angelou is used to reflect the suffering of her race, and to Maya Angelou, a bird struggling to escape its cage, trying to understand and respect both her body and her words. Virginia Woolf suffered from what she called looking-glass shame, an aversion to seeing herself in mirrors. How do we understand our own sufferings? With what words and to what ends? Call it what you want, but one thing very therapeutic is for us to find creative outlets for our pain. In Japanese, the word trauma is expressed with a combination of two characters, outside and injury. Trauma is a visible wound, suffering we can see, but it is also suffering made public. We are here to deal with realities. Victims of abuse, in fact, often do not disclose it, and if they do, it may not be until a substantial length of time has passed. Let us not stereotype victims of rape, particularly with the very much discounted doctrine of recent complaint. The court has reviewed Ms. Graves' police interview. For much of our history, the good rape victim, the credible rape victim, has become a dead one. When someone takes control of you and pushes their penis into your mouth, what can you do? It is frightening and shocking. That was Mr. Ururyar. Mandi Gray was intoxicated and typically could have been disassociated from herself, as she stated. This I accept. Who should remember the details of a rape? Miss Gray was very credible and trustworthy. Ms. Gray stated that she did not participate in anything from the time of sitting on Mr. Ururyar's bed until leaving the next morning. I accept her evidence. Of this, there is no doubt. The possibility of being pregnant, plan B. Rape it was, no confusion, no uncertainty to this court. Miss Gray was raped by the accused. Mandi Gray remembered what was important. Asking her to remember the details is ridiculous. The accused grabbed her hair, as she vividly described. He pushed his penis into her mouth and then intercourse followed. That happened, a nightmare. Who do we often blame for being raped? We blame ourselves. Miss Gray wanted an apology from the accused. She did not want to believe Mr. Ururyar had raped her. Who would? How could the accused possibly rape Miss Gray? He was supposedly sick. How did he have the strength to rape her, we are asked? Was he not anticipating consensual sex? Yes, but Mr. Ururyar was so angry, so angry, that he took power and control over Miss Gray and violently raped her. And he knew he raped her with his vague subsequent apology. I am sorry things went as they did. I shouldn't have said and done some of the things I did. I was upset and felt wronged by you, but that does not excuse my own mistakes. Miss Gray became the slut for the night because the angry accused wanted to seize on the opportunity of having a threesome, and Mandi Gray had ruined it. Miss Gray could not meet his sexual needs. She was vulnerable. She was scared. He pounced. Forget the condom. I am in power. Power, power, power. He was the boss and he loved it. The rape, the sleep, and the waking up. Enough was not enough for Mr. Ururyar. Miss Gray sees him masturbating, his wanting sex again. This time sober, less tired, Miss Gray left his apartment. Not again. There is a context for Miss Gray's behavior. The myths of rape should be dispelled once and for all. We cannot perpetuate the belief that niceness cannot coexist with violence, evil, or deviance, and consequently the nice guy must not be guilty of the alleged offense. Nice people supposedly don't rape. This is not society's image. The Crown has proven its case beyond a reasonable doubt. I therefore find Ms. Ururyar guilty of the charge before the court.
So, as I mentioned, the decision to include the feminist authors was very criticized in the media, and it was also used to overturn the case in the appeal. Can you chat about why you decided to include these and if you feel the criticism was fair?
I mean, the one reality is when people appeal cases, whether there's any foundation or not, they can use whatever grounds they want. You don't know who's going to hear it. You know, if it goes to the Court of Appeal, there's 3 judges. If it goes to the Superior Court, there's 1 judge. You know, from what I've read, one of the grounds of appeal will be the reference to academic journals. The Supreme Court of Canada, on many occasions, or occasion after occasion, to refer to academic journals. The sources that I quote respected authors, whether it's Maya Angelou, whether it's Lenore Walker in The Cycle of Violence, and I even put Lenore Walker, I even put a decision of mine from one of the family court decisions that I had that had been appealed, where I referred to Lenore Walker because she talks about the cycle of violence that should not be perpetuated. That was certainly accepted. But if the court or myself are being criticized for trying to deal with myths that were continued to be perpetuated and are perpetuated every day of every week without people knowing, from those who have worked with people who have experienced over and over again, why people react the way they react. So there was no way that, quite frankly, that I could write that decision without referring to the people I refer to.
Should judges be feminists?
It's a hard question to answer because the word feminist is very difficult. When you hear a case, you want to be, or you should be, as objective as possible. I think in this case, it was not just being a judge for 38 years, but I think it was having perhaps a greater appreciation and understanding of the facts, having sat as a family court judge for some 22 years, seeing and hearing similar types of cases. I saw this as an injustice. I saw the case, I saw as what happened as an injustice. I saw the myths that seemed to be perpetuated even in the courtroom as further evidence of injustice, saying to myself, this is 2016. Where have we come in the last 50 years? Women, and it can be men, are treated as property. I thought we did away with this. I thought our laws reflect that women are no longer property. They're no longer possession. There are no longer issues of ownership. And perhaps part of my feelings were reflected in the words I used. The only thing I can say with as specific as I could be and as certain as I can be is if it's a question of fact, there's no question of fact. He did what he did. There's no reasonable doubt. The facts that, as I found them, as far as I'm concerned, were correct. Judges have to make specific findings of fact, and there are findings of fact, and there's findings with respect to law. If anybody was there, if anybody heard all the evidence, if anybody read all the transcripts, there's no question in my mind that the decision was right. I found Ms. Gray was credible and trustworthy. I accepted her evidence. I made specific findings of fact, and on the other hand, Mr. Ururyar's evidence, firstly during the evening and at the right up to the very end, was simply unbelievable and not credible.
Do you think the state should provide victims with a lawyer?
Well, I don't think it's any different, quite frankly, than having a lawyer for an accused, as long as, of course, you're not telling people what to say. You're not telling people what answers to give, but you're preparing them for court. Lawyer can say, well, you're on cross-examination, you may be asked A, B, and C. As long as you're not telling them to lie, which of course people don't do, or tell them how to answer the question or make up an answer to the question. But if the bottom line is telling the truth and not being familiar with the process. I mean, I suppose hypothetically, a victim or a complainant in any case could go into a court on a particular day and watch the process. But many people don't know what the process is about. I don't know if it's the responsibility of the state. That's a good question. I suppose hypothetically, a victim can certainly hire somebody privately. I'm not sure that that would be the role of the state to prepare, because again, it's the Crown in a criminal case certainly whose job is to prepare witnesses for trial, really, and advise witnesses as to perhaps the kinds of questions they may be asked. So to find the accused guilty of sexual assault, the Crown must prove each of the essential elements beyond a reasonable doubt, which is true. Mr. Ururyar intentionally applied force. Ms. Gray did not consent to the force. He knew that Ms. Gray did not consent to the force that he, quote, in brackets, intentionally applied, and that the force that Mr. Ururyar intentionally applied took place in circumstances of a sexual nature. Sexual assault is about power, and that's what it was. It was about power. Power, power, power. He was the boss, and he loved it. It's not about loving sex. It's about hate. It's about hate.
Did you get a backlash from the public?
I did not expect to get a response. I must say that I heard from a few people that I haven't heard from in 50 years. And overwhelmingly, the people I heard with were very supportive. One person asked me, do you want to be appointed to the Senate? Of course, at my age, I would have been in the Senate about 2 weeks, and then I had to retire. No, I mean, I said, that's very kind of you, but unfortunately, I've almost reached retirement age. A few people have surprised me with their comments, but there were a few that I couldn't comment on what they said about me in an email or otherwise, but people have their own opinion. And again, and I put it in the sentencing, I made specific reference to statistics, because one of the criticisms is the feminist bias. Well, if 80 or 90% of the people that are sexually assaulted happen to be women, and that's Statistics Canada. And but I wanted to refer to that in the sentencing, just to make it clear that it wasn't coming out of left field. If they take away my pension, I'm going after each. No, I'm just kidding.
You mention citing statistics in the sentencing, and I want to explain to the listeners that in addition to deciding the verdict in a rape case like this, the same judge, in this case you, will also decide the punishment the person convicted of sexual assault will receive, and that punishment is called their sentence or their sentencing. So you also wrote a powerful sentence for Mr. Ururyar, and I want you to read some of that now.
Determination of a just and appropriate sentence is a highly individualized exercise that goes beyond a purely mathematical calculation. The question is always, what is fit and appropriate, or what is fit and appropriate really in the circumstances? Sentencing is about communicating society's legitimate shared values and concerns. The crime I described is one of gratuitous violence and committed in the very home of the offender. Arguably, jail is a last resort. The fundamental purpose of sentencing is to protect society and also to denounce unlawful conduct, to deter the offender and other persons from committing offenses, to separate offenders from society, to assist in rehabilitating offenders, and to provide reparations for harm done to victims or to the community. Those that commit the crime of rape must understand that they do so at their peril. A just sentence is one that reflects the seriousness of the crime and fits the individual circumstances of the accused. The victim impact statement is provided under the Criminal Code of Canada. The victim can read out a victim impact statement or choose not to read it, and the court can consider the victim impact statement. The victim impact statement cannot suggest what the appropriate penalty the court should impose, but certainly it provides the court with an important aspect, particularly in this kind of offense, as to how the sexual assault impacted on the victim. So certainly in this case, it's very important and reflects, as sexual assaults do reflect, or assaults do reflect, the fact, as I indicated in the original decision, that pain has no time limit and suffering may go on literally forever. Hope is a stubborn thing, and at some point it is too rosy a word for reality, for denial, and for delusion. Having insight into the suffering of those who may have been raped on any level gives some level of empathy towards those who may walk through our doors. I mention this because it is about empathy. It is about understanding. It is about feeling, or hopefully feeling, the pain that others have suffered. It is the opinion of this writer that the subject should not be with any female person alone while she's intoxicated. That's Mr. Ururyar. The subject reports that he is not interested in taking part in the sex offender treatment program, and his lawyer is appealing his conviction. Given his not complying attitude at this time, the subject is not suitable for any community programming at this time. The gravity of rape cannot be diminished. Rape is not an accident. Given Mr. Ururyar's complete lack of credibility and self-serving version of events, I would not assume that he will not continue to be a danger to others. I've considered the future risk management, or the future management of risk. There must be no repetitions. There is a canyon of difference between bad decisions and rape, between evidence of goodness or perhaps redemption. We are all planks in a bridge. It is not like running a race. We don't take a baton and pass it off with the victim. We must all work together to get the victim from where they are to where they need to be. For a victim of sexual assault, the notion of justice is far more complex than who goes to jail and for how long. For victims, their idea of justice may well be different from what ours is. We must no longer say we don't have enough to move forward with your case and hang up the phone. Victims deserve a new solution, not a stale policy. Many women are raped in this city, in this province, in this country every day, and many of them are themselves raped every day of every week. I am imposing a period of 18 months imprisonment, followed by a period of probation of 3 years with appropriate terms and conditions.
And why did you add the community service?
A person should give something back to the community, and maybe that is therapeutic. Maybe that's helpful. Beyond any sentencing, the probation and going for counseling. And maybe with counseling, there's so many variables and so many issues that come into play. We're in a very multicultural society, and people bring their own thoughts and their own ideas, and it's difficult, And of course, also, how do we deal with perpetrators so they won't victimize again? But somebody assaults their friend or sexual, I'm sorry, and then what happens? They're nice, and then they do it again. If you're a nice person, supposedly, it's the same thing with calling character witnesses. The reality is, and our courts have said the same thing. How would anybody know anything about someone when most of these things, 99% of the time, happen behind closed doors anyway? So you don't really know the real person. You can get reference after reference. Oh, he's a nice person, he wouldn't do that. Well, how, for goodness sakes, would somebody really know? That just as people that may be addicted to drugs, you hope that people that commit sexual assaults are not addicted to committing these kinds of crimes. And people are criticized for reporting, and yet it's by reporting that people will know, because people probably know they're not going to do anything anyway. If my daughter was sexually assaulted today, I would say if you don't report it, then it's easier said than done. The person will do it again. I even tell my students at OISE, I said, and now the thing now in a different area, of course, is sexual harassment. Create a paper trail. Emails between people, if inappropriate, you send an email or create a paper trail saying, this is inappropriate, don't do it again, or then we get into criminal harassment.
If you could wave a magic wand and change something, what would you change?
Well, right now, sexual assault is either a summary conviction or indictable offense. Whether the government should change that option or remove the option and simply make sexual assault indictable offense, I don't know. Whether the penalty, certainly with respect to indictable offense, should be increased, that would be up to the government. The bottom line to me is respect, learning respect. So I think as much as it is necessary changing the law is focusing on education, young people. We shouldn't have to wait until we're dealing with university students or graduate students to know what respect is about.
I should mention also that before you craft the sentencing, the victim submits what's called a victim impact statement about how the sexual assault affected his or her life. Can you speak to how that influences your decision on sentencing, or does it influence it?
Well, the victim impact statement, I think and the legislation, the criminal code has been amended, and it has been expanded to the extent that victim impact statements are not limited to the victim themselves. There could be family members as well who could provide victim impact statements. You do what you believe is right, and these cycles that I have seen that perpetuate themselves, is something that we have to deal with. I dealt in family court with mothers who were 14 or 15. They become grandmothers at 30 or 32. My experience is that women who may have been sexually assaulted or were sexually assaulted end up with partners who are abusive because of what happened to them. And also something besides the criminal laws is, how do we help victims after? What about the victim or victims who can't afford counseling, who don't have benefits, who aren't working, who aren't employed? So I think there's so many there's so many areas to deal with. And another area, and I remember being on a thesis committee where the subject was victims whose first language was not English. So I think the criminal laws are one area, but certainly how do we help victims? Victims, complainants could have a screen between them and the accused so they don't have to see the accused in some cases. I've dealt with sexual assaults involving children. Children would be in a separate room. It's a reflection of how sick a world that we may be living in. We live in a society where, unfortunately, there are a lot of very sick people, but that's the reality, I don't think it is the process so much that's bad. It's the thinking. It's the thinking that has to change. It's the understanding and the thinking. We have to be on the same wavelength about the myths of sexual assault, about the understanding of what these crimes are about. That's what I think has to change. More than the system. I think the system can work. We all have to help each other and educate each other. That's all. Okay.
Listening to this interview again, I can't help but think that part of the process is broken. The beautiful verdict that Zuker wrote was overturned in the appeal court. The man accused of raping Mandi Gray never did community service, and he never served his 18-month sentence in prison. He never had restrictions about being around females and drinking alcohol. Everything was overturned in the appeal. Instead, he got a 1-year protection order stipulating that he would not go near Mandi Gray. This in Canada is known as a peace bond. She could have gotten the same thing just from a stalking charge or a harassment charge or even a trespassing charge. Not only did he never serve his sentence, but the maximum time the peace bond could be legally applied was only for 1 year. Now that year is coming up. Now Mandi faces seeing him around the corner, in the hallways, at the food court of her workplace, as he has also returned to teach where she teaches. So I ask you, if the system is broken, which it appears to be, what now for victims of sexual assault? What now for the average person wanting to help prevent sexual assault? Is it really thinking that's the problem? Or is it our actual laws in place that are the problem? Changing the legal system sounds impossibly hard, but what is the alternative? Protest? Doxing? Public shaming? I'm not suggesting these, I'm just throwing them out because I don't know what else to do. Just what is the point of spending hours and hours reporting to the police, going through a trial, missing work to go to the hospital to get a rape kit done, having your personal details laid public and published as public record, possibly missing God knows what, birthday parties, work events, whatever, to appear in court, just to have the person who assaulted you return to work with you a year later after the peace bond expires. And speaking of the peace bond expiring, why can't we have peace bonds that last forever? What's the point of having it expire after 1 year, which apparently is the maximum that a peace bond can last? Why can't we have it indefinitely, until the person accused of the assault dies? How about that? or until the victim dies. Why would you need to go through the bureaucratic headache of renewing a protective order every single year? I just don't get it. Anyway. Thank you so much, and please remember, if someone discloses a sexual assault to you, please listen and support them.